This is a good one, y'all. We got proof that they don't erase some shit out of Nolan Wells' phone.
Alright, everyone. Before we get into this video, I want you to pay close attention. What you're about to watch is a compilation of material from several commentators who have been closely following the Nolan Wells case. Some of what you'll hear comes from strong emotions, some is speculation, and some raises questions that still genuinely deserve answers. Let me be clear about something. This channel separates information that can be confirmed from things people simply believe. The video you're about to watch includes both. So here's how we're going to handle it. We'll go through the material together, and afterward, I'll walk you through which parts can actually be verified, which parts are interpretation, and which questions remain unresolved. You're going to hear claims about Snapchat messages that were supposedly on Nolan's phone, but later could not be found. You'll also hear about audio engineer Janetta Brantley, who worked to separate voices from what has been identified as the CTO call. You'll see discussions involving photographs, boats, and names that were not publicly known until certain recordings came to light. Some of this may feel like a lot to take in. Some of it may sound convincing, while other parts may make you stop and question what you're hearing. And honestly, that's exactly what you should do. Here's the main thing I want you to remember as you watch. Passion is not proof. A detailed theory does not automatically become confirmed evidence. And just because something appears to make sense doesn't mean investigators or officials have actually established it as fact. That being said, some of the questions brought up in this video are legitimate. Some of the inconsistencies being discussed may deserve further examination. And some of the frustration you're about to hear from the public is completely understandable, especially when a family is still waiting for answers 48 days later. So, watch this with your critical thinking fully switched on. Don't simply accept every statement because it sounds convincing. When we're finished, we'll go back through the major points and separate what holds up, what doesn't, and what still needs to be explained. With that in mind, let's get into it.
This is a good one, y'all. We got proof that they don't erase some shit out of Nolan Wells' phone. Not only that, we found Janetta Brantley, the audio engineer of the CTO call who separated the voices. We found her TikTok, y'all. Y'all not gonna believe what she broke down because nobody was thinking about this and nobody mentioned it. And when you think about what she about to say, it's gonna let you know that this CTO call is real, even though we already knew it was real, but this is definitive proof that it's real. Y'all ain't gonna want to miss this one. Y'all make sure y'all hype this video. Make sure you're hitting the like button and make sure you subscribe. Check this out, y'all.
Yeah, not Mr. Bobs came through with the tea and told us that Snapchat sends all of their users every 4th of July a happy 4th of July message, text message, whatever it is. You don't believe me? Let him tell you.
You gotta laugh at how stupid y'all are. So Snapchat will send you a text every holiday. Happy 4th, a whole thing. Y'all deleted that.
Because I know how y'all are is where's the proof? Here's the proof. I dropped it in chat and this is what he said. That we got the proof in the pudding. I think y'all deleted some stuff out the Snap, out of the phone. I think y'all really did. Warren, you said he didn't take anything. He didn't. Your words. But have a great day, because that was some tea right there.
Here's what we know. Snapchat does send automated messages on certain holidays, and that part appears to be accurate. Those messages can show up in your chat history when they are received. But here's what we still don't know. We don't know whether Nolan's account was configured to receive those messages, whether his notifications were turned on, or whether that particular message was actually sent to his account that year. We also don't know whether anyone has directly confirmed with Snapchat what was or wasn't delivered to Nolan's account on July 4th. So, could this be a lead? Does it prove that something was deleted? Not at this point. That's an important distinction. A forensic examination of the phone, along with relevant Snapchat records, could potentially help answer those questions. And that's precisely why the phone needs to be forensically examined.
Here's the problem with the DA's last statement on the Nolan Wells investigation. If you read it fast, or you're not a lawyer or a former prosecutor like me, you may have missed it. So let me show you. Right after Nolan's family's lawyers published letters they sent to her office, the DA told the press she doesn't have the same freedom as private individuals. People, she says, may publicly adopt a narrative and choose one fact over another, who may be able to control what bits of information they share, and whether it's in context, twisted, or misconstrued. I totally get that sometimes the DA can't publicly comment on an active investigation, but that's not all she said. The problem is the timing, the framing, and the selectivity with which the DA chooses to engage the media. You know when she was silent? When attorney Tyler Cox went on the Dan Abrams show with the narrative that the victim's family wasn't cooperating with her office. Crickets when Judge Ashley Cole, an elected judge with additional obligations under the judicial conduct rules, publicly shared bits of information surrounding an active investigation. But now, when the victim's family tries to clear up confusion, she decided it was time to go to the press and talk about misconstruing facts and choosing narratives. Only when Nolan's family's lawyers speak up. She says public commentary doesn't make a speaker transparent. But what is transparent is how questionable law enforcement's engagement has been with the victim's family. You know, the people who loved and raised Nolan. The people who just want answers.
That observation is fair. The DA did release a statement shortly after attorneys representing the family raised concerns and sent letters. The timing can certainly be questioned, and the video makes the argument that this was selective engagement. That is a reasonable point to raise. But there is another side to consider. Prosecutors are restricted by legal and ethical rules when an active investigation is still underway. DA Angel Myers-McElrath addressed those limitations in her statement. She explained that she cannot publicly release evidence, discuss witness cooperation, reveal testing details, or simply confirm which claims are true or false. She does not have the same freedom as private attorneys, family members, or online commentators. Does that automatically mean the timing of her statement was strategic? Not necessarily. It could have been, but the timing alone does not establish that she is hiding anything. It means she is working under a different set of legal responsibilities and restrictions. The frustration expressed in the video is understandable. Families naturally want transparency, especially when they are still waiting for answers. At the same time, we also have to recognize that the state autopsy report and other evidence are being withheld while the case moves through the grand jury process. McElrath has said she is obligated to present the investigation and evidence to the grand jury before the information can be made public. So, this is less about one person simply choosing not to release a report and more about how the legal process is structured in Mississippi. That distinction matters when trying to understand why certain information remains unavailable right now.
Y'all, look at this. Do y'all see this? This was about an hour ago. But didn't Reverend Al Sharpton already tell y'all that he challenges, and now he's telling y'all right here that he welcomes this alleged litigation, because he said now that he can get the truth. He's been telling y'all, he told y'all that on at the funeral, and he says apparently while he was doing the visual on Nolan's birthday, he said that he didn't say, he doesn't know anyone's name or was specific, but he said 3 of those boys logged into the Zoom, because I guess they must have been Zooming the vigil, and they logged into it, and he said that he would appreciate for them to come forward. How is that defamation when he's asking questions? We all have the right to ask questions. But anyways, you see what he said right here? It's about to get messy, y'all.
Y'all go ahead and screenshot, read it. See, what people fail to realize is that Reverend Al Sharpton is well connected. When you got somebody that's been in the game as long as him, he is not to be messed with, y'all.
That's not simply speculation. It's a public statement made by a named individual. And the legal process he's referring to is a real mechanism. If someone files a defamation lawsuit, the discovery process can potentially require the disclosure of records, communications, and sworn testimony. Is he trying to provoke a lawsuit? Maybe. Does he sound confident about what he knows? Absolutely. But does that prove anything about what happened on the island? That's an important distinction to keep in mind. What it does show is that someone with decades of experience handling civil rights cases believes there is enough information here to justify taking a closer look. That doesn't establish what happened, and it doesn't confirm every claim being discussed. But it does explain why his statement has attracted attention and why some people believe the legal questions surrounding this case deserve further examination.
Y'all remember on July 27th when Brandon Tatum shared the breaking news, which was supposedly the evidence of the young adults on the boat being towed, right? If you don't remember, let me show you right quick. More importantly, let me make sure we all see the date.
July 27th.
How is it that at this latest interview, that same exact evidence is now evidence of them on the phone with Cito?
I just want to make this very clear and abundantly clear for the audience. Are you saying that the video that I posted, which is like a 3-second loop, now I have a lot more of the video, but to not expose people that have nothing to do with this, I only posted the smaller part, the 3-second part. Are you saying during that time, a portion of that, why it was on the phone with Cito, so a portion of that is the Cito call, and that Nolan is not on that boat?
Correct.
Which one is it? How can the same set of photos and videos be used as evidence or proof of two different things? How is it also evidence of them being on the phone with Cito, calling for a tow, needing a tow, while also being towed? Make it make sense. See, the difference between me and Tatum is I've been transparent and honest since day one.
Her defense is pretty straightforward. How could I create voices belonging to people I had never heard before? And how would I randomly come up with the name Bart if I had never heard that name associated with this case? That's a compelling point. If the name Bart truly had not been mentioned publicly before the audio was released, and she had no previous connection to anyone involved, then there are only a few possibilities. Either she somehow guessed a name that later became relevant, or the audio is authentic. But here's what could actually help settle the issue. An independent forensic examination of the audio, performed by someone with no connection to either side. A neutral audio expert could examine the original recording, look for possible signs of editing or manipulation, and provide a professional report. That's the kind of analysis that would carry much more weight. Until something like that happens, we're left with her professional reputation on one side and allegations that the recording was fabricated on the other. The appearance of the name Bart before it was reportedly known publicly is certainly interesting. It doesn't establish the authenticity of the recording by itself, but it is a detail that deserves attention and should not simply be brushed aside.
You put out, Brandon, that a clip of the boat when Wyatt was on the phone with Cito.
Hey, we're at the west tip of Bourne, and our village pump stopped working. We're sinking. Can y'all please come? We have a membership.
You can literally almost see down to the deck.
It's coming up. We're just sinking. I don't know. Like we're going down now.
And as you can see in that picture, everybody is completely casual while Wyatt's on the phone with Cito. Yeah.
Oh my God!
Boldly clear that Nolan was not on the boat with us.
If we were sinking, yes. Oh, we're not aground. We are in 17 foot of water. We're in 31 foot of water.
We're in 31 freaking feet of water, lady. Get out of here. Listen, bruh. They want this story to die down so much, but we gotta refresh in their minds. Janetta Brantley has a TikTok, y'all, and it's underscored that girl Netta. Watch what she say for all the people that are saying she forged that audio from the Cito call. Check this out, y'all.
If I supposedly used magic AI or some other Hollywood level audio trickery on a publicly available recording, I got a couple of questions. First, where exactly did I get everyone's voices from if I've never met or heard any of those young adults before? One. And two, and most importantly, how did I randomly invent the name Bart? I'd never heard that name connected to this case before. So according to the conspiracy theory, I not only fabricated voices out of thin air, I also somehow guessed the name of someone who was allegedly there. That's not audio engineering, that's psychic powers or something. And at some point, the explanation requires more imagination than the audio ever did.
Your girl is actually getting some rest today. And while I was getting some rest today, I went back and watched the second interview again. And I don't know if I shared this piece of gem with you guys, but let me share it with you just in case I haven't. Listen.
Oh, the audio comes back, and all of a sudden we can hear Nolan yelling in the background, screaming, we're screaming about how he's dead.
What did you just say, Warren? Let's slow it down.
Oh, the audio comes back, and all of a sudden we can hear Nolan yelling in the background, screaming, we're screaming.
At this point, we already know that the Cito call is real, but Warren yet confirms again himself out of his own mouth saying that Nolan was in the background screaming. And then you saw how he paused, and then he's saying, they just telling on themselves. Like, we wouldn't know, because from what I've known, no one has never said anything about, we literally are hearing Nolan screaming in the background. We've said a lot of people, other people that were on the boat were screaming, not Nolan. I digress, though.
I remember seeing a post that Bart Edmiston allegedly posted and said, Junior came home and he and Brooks took Hawk out trout fishing. Brooks caught the one that didn't get away, ... in the back of the head. It wasn't until July 22nd that Ben Grump stated the autopsy of Nolan Wells.
Focal area of red discoloration in the soft tissue of the back of the head, the occipital region.
This was stated July 19th. Is it a coincidence that Bart Edmiston allegedly posted this 4 days before the autopsy results even was made into the public's eye? This is one of the alleged 3 boats that they used to go to Horn Island July 4th, friend Bart on the way up to Horn Island. But if you look at this photo, I don't see Warren anywhere.
There is a lot of people asking questions about this boat video. And when I read the comment section, you're all asking the same thing. What boat is that? Was that the same day? Is that the same day? Is that the same day? No, I don't believe it's the same day. The main reason why she posted the video in the beginning was to show that he was with a group. And if the young man was saying that the group was so tight-knit, this must be the same people who he was with on 4th of July. That's all she was saying when she posted the video. That's it. Again, nothing is stating facts when we're reacting to these videos. We're not insinuating that these are facts. This is what happened. These videos is just to get people thinking and put things together. On top of that, have a record of everything, y'all, because we cannot rely on the news. We cannot rely on the people of Mississippi.
1213 for sure on this boat. Who's that? Who is that back there? That's Nolan, right? That's Nolan. On this boat that is not a tide line, it's not a tide craft, it's not a Triton, and it's not a Palm Beach. Okay? So long as...
But one thing we can say is that is Nolan Wells right there.
Got us over here thinking we're looking at the right information and dissecting a CTO call on a Triton and all this shit. He's the supervisor. He runs the joint. He runs Mississippi Department of Marine Resources, MDMR, putting out these reports to keep y'all busy looking for a Titan and a tide line, a tide craft, and a Palm Beach. And none of it has to do with what happened to Nolan that day, okay? Not only is Mr. Freeman here, the boss, writing the reports, he happens to just also happen to work for Forensic Science Services, LLC. So don't think that if you're a mama looking to find out the truth, you might be able to go hire a company doing forensic services about marine shit and go get the truth, because he works for them too.
They all connected.
This is for those that are honestly looking for the truth. I don't care whose feelings anything I say hurt. I don't care. I don't care about anybody's feelings, and neither does the truth. And the truth's all I'm looking for here, okay? Anybody that's meant to hear this, God's going to have you here today to hear what I've got to say, because nobody else is telling you what I'm telling you in this moment. No one. I don't know who's responsible for the actual death of Nolan Wells. That I don't know. I know all these people are a part of covering up what the heck it ever was. People at CTO, the people at MDMR, all of them. All of these people have participated, including Tatum. All of them. You hear me? Tatum should be brought up on conspiracy charges as far as I'm concerned, along with these other people. They have actively and willingly participated in covering up whatever the truth is about Nolan Wells. And whatever that truth is the truth I'm here to find out. I have tried to consume every little piece of information available to me. I have done the research behind the scenes. I have studied. I'm not just talking out my booty here. Okay? I've pieced together what they've told me, and I've put it with what they provided for evidence, and I'm here to tell you it's a lie. It's not the truth. They've got us looking at boats that are not involved and it's wasting our time. If we're going to be online debating whether or not that sea talk, all of that's fabrication. All of it, every bit of it is fabrication. I wish to God Tatum, Cox.
Y'all remember this picture right here that Warren had posted? This was AI. Everybody stepping on each other's feet in the picture. They feeding us AI pictures and AI videos and shit.
Or Paulsnick would come up and talk to me and let me ask him some questions. I'll prove every one of them are fake. On the spot in real time. So I'm not fearful of anybody wanting to threaten me. They're going to let somebody know I'm over here talking shit. I ain't talking shit. I'm talking facts, and there's nothing they can do about that. I'm not worried about getting in trouble for the truth. That's the last thing on my mind. So I'll show you again here what's all wrong with this. You hear me? Pay attention. Look how much older Nolan is. All these guys are younger. They've got an older Nolan. That's all they've got to work with. You see? They weren't Nolan's friends. That's why they have to fake pictures. The street light behind his head, you don't get the light coming around in front of your head from a street light behind you. Look what they did down here on the feet, y'all. They put Nolan in this one and this one in the same identical flip-flops, who are notably Warren's. He wears them in every interview. These are identical legs. Do you see that? Those are identical down to the little crinkle on the same... You see that crinkle on the same leg? And then I got to looking. Not only are these two standing off the edge, you guys, which they are, these are the same feet. They put the same damn feet and shoes on these two guys. You can see the cutout around all the guys' head. Look at that. Don't make no sense for that light to be there. Look at the outline. What a terrible crop job they've done. They've got white wall tires. I'm old. These boys ain't that old to know about the white wall tires, guys. The black car.
They AI'd a picture just to make it look like they was tight knit, to push this tight knit agenda.
So you heard what's going on now, right? Bart, which is one of the gentlemen that was on the boat, I guess. He started dropping names. He then dropped 20 different names. So now the friends is mad at him. But you see how God is shaking up that tree? See, people don't understand. You can talk about us, but see, we trust God. And when I tell you God is going to shake up the foundation over there in Mississippi, over there in Jackson, let me tell you something. Or whatever city or township that's in, God is shaking up the tree where now they talking and they telling on each other. Bart, as you can see, he's dropping names. Now they pissed with him. Why you put my name in it? Listen, family, God is shaking up the tree and them cats is going down. Don't play with God. Don't play with God.
That's the end of the video. Y'all hop in the comment section. Y'all let me know what y'all think, man. She said, look, ain't nobody even heard Bart's name. Who the hell is Bart? Until we heard the Cito call. That goes to show you that it's real. And for Snapchat to send out something every 4th of July and it ain't there, what are we talking about, y'all? Also, don't forget, they are trying to let this die down. They want the people to forget Nolan Wells' name. So what I'm going to ask y'all is to go in the comment section and y'all write justice for Nolan Wells, because we got way too many leads, y'all, to let this go. This ain't like them other cases where we ain't got no leads and we ain't got no choice but not to talk about it because they ain't that many leads. But this one right here, we cannot let this slip through the crack of our fingers, y'all. We got to be on it. So make sure y'all like, hype, and subscribe to this video and get in the comment sections. Let me know what y'all think, man.
The alleged Bart Edmondson social media post is one of the details that deserves careful examination, but the first step is to establish that the post actually exists in the form being described. If the post is genuine, if its original publication date can be verified as earlier than July 22, 2026, and if it really contains language referring to a condition involving the back of Nolan Xavier Wells' head, then the timing would be worth investigating. July 22 matters because that was the date attorney Ben Crump publicly announced preliminary findings from the independent autopsy commissioned by Nolan's family. Those findings included a reported area of red discoloration in the soft tissue at the back of Nolan's head. The finding was not presented as proof of an assault or as a final explanation for his death. It was a physical observation whose cause remained unresolved. There is also an important timing issue here. A later public statement cannot be used to prove that an earlier person knew the information unless the earlier record is independently verified. The date has to come from a reliable source, not merely from the person describing the post today. If the original account still exists, investigators can examine the visible history. If the platform record is unavailable, other independent records may be needed. This is why preserving digital evidence early can matter so much. Online material can disappear, accounts can be deleted, and posts can be changed. A claim becomes much easier to evaluate when the original source has been preserved before interpretations begin to spread. That brings the focus back to the central question in this part of the story: what can actually be established? Point 1 is useful only if it is connected to evidence that can be checked. The fact that a claim sounds plausible does not make it established. The fact that a detail is unusual does not automatically make it suspicious. And the fact that several people online reached the same conclusion does not turn that conclusion into an official finding. What matters is whether the underlying source can be verified, whether the timeline holds up, and whether independent evidence supports the same interpretation. That standard should remain consistent no matter which side of the debate a piece of evidence appears to favor. That distinction is important because an unusual detail can be significant without proving the theory built around it. A social media post that appears to predict a later public medical detail would be a lead. It would give investigators a reason to ask where the information came from and whether it was available elsewhere. It would not, by itself, establish that the person who posted it had access to a private autopsy report. There could be other explanations, including earlier rumors, private conversations, photographs, or information that had not yet reached the wider public. The correct response is therefore to preserve the original material, verify the date, compare the wording, and determine what information was actually public at the time. The wording of a supposed earlier post matters just as much as its date. A vague statement about someone having an injury would not necessarily correspond to a later medical finding. A very specific phrase might deserve closer comparison. Investigators would need to compare the exact language rather than relying on a paraphrase made weeks later. They would also need to determine whether the wording was ordinary language that many people could have used independently. This is especially important when a case receives heavy online attention, because phrases can circulate quickly through videos, comments, group chats, and private conversations. That brings the focus back to the central question in this part of the story: what can actually be established? Point 2 is useful only if it is connected to evidence that can be checked. The fact that a claim sounds plausible does not make it established. The fact that a detail is unusual does not automatically make it suspicious. And the fact that several people online reached the same conclusion does not turn that conclusion into an official finding. What matters is whether the underlying source can be verified, whether the timeline holds up, and whether independent evidence supports the same interpretation. That standard should remain consistent no matter which side of the debate a piece of evidence appears to favor. A screenshot is not the same thing as an authenticated original post. Screenshots can be cropped, edited, rearranged, or separated from the surrounding information that would establish context. That does not mean a screenshot is automatically fake. It simply means that a screenshot has limitations. If the central question is when something was posted, the strongest evidence is the original platform record or another reliable source that can establish publication history. Investigators or journalists should preserve the account, the original post, the visible date information, and any available platform records. If the post was edited after publication, that should also be documented. The goal is to establish what was actually posted and when, rather than relying on a copy that may have passed through several people. There is a temptation in cases like this to treat a matching detail as a direct connection between two events. That can be misleading. Two details can match without one causing the other or without one person having privileged information. The proper question is whether the connection is supported by independent evidence. If a post predates the medical announcement, if the date is authenticated, if the wording is unusually specific, and if investigators can establish that the information was not available through another source, then the lead becomes stronger. Even then, it would remain a lead until the source of the information is established. That brings the focus back to the central question in this part of the story: what can actually be established? Point 3 is useful only if it is connected to evidence that can be checked. The fact that a claim sounds plausible does not make it established. The fact that a detail is unusual does not automatically make it suspicious. And the fact that several people online reached the same conclusion does not turn that conclusion into an official finding. What matters is whether the underlying source can be verified, whether the timeline holds up, and whether independent evidence supports the same interpretation. That standard should remain consistent no matter which side of the debate a piece of evidence appears to favor. The July 22 independent autopsy announcement also needs to be described accurately. Attorney Ben Crump represented Nolan's family and presented preliminary findings from the examination performed by forensic pathologist Dr. Roger Mitchell. Multiple reports said the cause and manner of death were undetermined pending further investigation. The examination was limited by decomposition and by the availability of certain parts of the body. The red discoloration described in the tissue at the back of Nolan's head was a finding, not a final determination about what caused it. That means it is reasonable to ask about the significance of the finding, but it is not accurate to turn that finding into proof of a particular act without additional evidence. The same evidence-first approach applies to the boat discussion. A vessel's movement is only one part of the story. Investigators also need to establish who was aboard, who was on shore, when people entered or left the water, and which observations are based on direct knowledge versus later recollection. GPS can help with movement, but it does not replace witness evidence or physical evidence. Conversely, witness memories should not automatically override objective records. Each source has strengths and limitations, and the most reliable timeline is built where independent sources agree. That brings the focus back to the central question in this part of the story: what can actually be established? Point 4 is useful only if it is connected to evidence that can be checked. The fact that a claim sounds plausible does not make it established. The fact that a detail is unusual does not automatically make it suspicious. And the fact that several people online reached the same conclusion does not turn that conclusion into an official finding. What matters is whether the underlying source can be verified, whether the timeline holds up, and whether independent evidence supports the same interpretation. That standard should remain consistent no matter which side of the debate a piece of evidence appears to favor. The boat issue is another area where precision matters. If investigators are reconstructing Nolan's movements, They have to know which vessel is being discussed at each point in the timeline. A boat can be identified by registration, photographs, GPS information, witness descriptions, or other records. If different sources use different descriptions, those references should be reconciled before anyone concludes that the contradiction is evidence of intentional deception. Confusion can come from different names for the same vessel, incomplete reporting, witnesses remembering events differently, or people referring to different boats at different stages of the day. A genuine discrepancy should be investigated, but the existence of a discrepancy alone does not establish a conspiracy. A confusing boat description should therefore be treated as a problem to solve rather than a conclusion to announce. If an official record lists one vessel and another record appears to describe a different vessel, investigators can compare registration numbers, photographs, ownership information, GPS tracks, and dates. If the vessels turn out to be different, the next question is why both appear in the public discussion. If they turn out to be the same vessel described differently, that explanation should be made clear. Either way, the issue can be resolved through records rather than speculation. That brings the focus back to the central question in this part of the story: what can actually be established? Point 5 is useful only if it is connected to evidence that can be checked. The fact that a claim sounds plausible does not make it established. The fact that a detail is unusual does not automatically make it suspicious. And the fact that several people online reach the same conclusion does not turn that conclusion into an official finding. What matters is whether the underlying source can be verified, whether the timeline holds up, and whether independent evidence supports the same interpretation. That standard should remain consistent no matter which side of the debate a piece of evidence appears to favor. GPS information can help establish movement, but it cannot answer every question about what happened on an island. Public reporting has described GPS data associated with the boat Nolan traveled on to Horn Island, including its trip to the island and its later departure. That information can help anchor the timeline. It cannot automatically establish who was standing where, what people were saying, or what happened away from the vessel. Those questions require other evidence. The strongest reconstruction comes from combining GPS information with witness statements, photographs, video, phone records, emergency communications, and other independent sources. If two sources conflict, investigators should compare their reliability rather than simply choosing whichever version supports a preferred theory. Digital evidence has a similar structure. A phone can contain information, but the absence of a visible message is not automatically evidence that someone deleted it. It could have been deleted automatically, never delivered, stored elsewhere, or removed by an application according to its normal retention system. A forensic examiner can investigate those possibilities. Provider records may also be important because some services maintain information separately from the physical device. The important point is that the answer should come from the digital evidence itself rather than from what people assume a phone normally contains. That brings the focus back to the central question in this part of the story: what can actually be established? Point 6 is useful only if it is connected to evidence that can be checked. The fact that a claim sounds plausible does not make it established. The fact that a detail is unusual does not automatically make it suspicious. And the fact that several people online reach the same conclusion does not turn that conclusion into an official finding. What matters is whether the underlying source can be verified, whether the timeline holds up, and whether independent evidence supports the same interpretation. That standard should remain consistent no matter which side of the debate a piece of evidence appears to favor. The allegation involving an AI-generated or manipulated photograph should also be approached carefully. A commentator pointing to unusual pixels or lighting in a YouTube video is not the same as a forensic image examination. Images can look strange because of compression, resizing, screenshots, social media processing, camera software, or ordinary lighting. The supplied material refers to XIF data, but the standard term is EXIF data. EXIF information can contain camera settings and other technical details, although social platforms may remove metadata when an image is uploaded. The absence of EXIF information does not prove that a photograph is fake. If authenticity is genuinely in doubt, The original file should be preserved and examined by a qualified forensic image analyst. The photograph allegation deserves the same restraint. Modern images are processed by cameras and phones before users ever upload them. A photograph can therefore contain artifacts that look unusual without being fabricated. Social platforms can compress an image again, remove metadata, or create the new file from the original. That makes visual inspection alone unreliable for serious conclusions. If the original file can be obtained, a forensic examiner has a much stronger foundation for determining whether manipulation occurred. If the original cannot be obtained, that limitation should be clearly stated. That brings the focus back to the central question in this part of the story: what can actually be established? Point 7 is useful only if it is connected to evidence that can be checked. The fact that a claim sounds plausible does not make it established. The fact that a detail is unusual does not automatically make it suspicious. And the fact that several people online reached the same conclusion does not turn that conclusion into an official finding. What matters is whether the underlying source can be verified, whether the timeline holds up, and whether independent evidence supports the same interpretation. That standard should remain consistent no matter which side of the debate a piece of evidence appears to favor. The cover-up allegation requires an even higher standard. The supplied discussion accuses multiple parties, including CATW and the Mississippi Department of Marine Resources, of being connected to a possible effort to obscure the truth. Because that is a serious accusation, relationships and employment records are not enough to establish it. To prove intentional concealment, there would need to be evidence showing that people knowingly hid, altered, destroyed, or misrepresented material facts. Someone working for a related organization does not by itself establish wrongdoing. A report that another person considers incomplete or inaccurate does not automatically establish intentional deception either. Errors, disagreements, and incomplete information can happen without a coordinated cover-up. A cover-up allegation also needs to distinguish between incompetence, disagreement, and intentional misconduct. A report can be incomplete without being deliberately false. An agency can make a mistake without coordinating with another agency. Two officials can interpret the same information differently without secretly working together. To establish intentional concealment, investigators would need evidence showing knowledge and purpose. That could include communications, instructions, altered records, destroyed evidence, or other material showing that someone deliberately acted to hide a significant fact. Without that kind of evidence, the accusation remains unproven. That brings the focus back to the central question in this part of the story: what can actually be established? Point 8 is useful only if it is connected to evidence that can be checked. The fact that a claim sounds plausible does not make it established. The fact that a detail is unusual does not automatically make it suspicious. And the fact that several people online reached the same conclusion does not turn that conclusion into an official finding. What matters is whether the underlying source can be verified, whether the timeline holds up, and whether independent evidence supports the same interpretation. That standard should remain consistent no matter which side of the debate a piece of evidence appears to favor. The phone remains one of the most potentially useful pieces of evidence discussed in the wider material. A proper forensic examination could potentially reveal communications, application activity, stored files, or other digital information, although no examination can guarantee that every deleted record will be recoverable. Modern phones and applications use encryption and different retention systems, and some information may exist only with a service provider. That is why assumptions about what should be on the device need to be separated from what a forensic examination can actually establish. The same principle applies to Snapchat. The existence of automated holiday-related content does not by itself prove that a specific message was delivered to Nolan's account. Delivery would need to be established through appropriate records. The medical findings require the same careful language. A red discoloration finding is not a diagnosis by itself. It is a physical observation that needs interpretation in context. Decomposition can complicate forensic interpretation, and the independent pathologists report acknowledged limitations. That is why it would be inaccurate to tell viewers that the finding proves an injury caused Nolan's death. The responsible wording is that the finding was reported and that its significance remained unresolved. Future evidence may clarify it, or it may remain inconclusive. That brings the focus back to the central question in this part of the story: what can actually be established? Point 9 is useful only if it is connected to evidence that can be checked. The fact that a claim sounds plausible does not make it established. The fact that a detail is unusual does not automatically make it suspicious. And the fact that several people online reached the same conclusion does not turn that conclusion into an official finding. What matters is whether the underlying source can be verified, whether the timeline holds up, and whether independent evidence supports the same interpretation. That standard should remain consistent no matter which side of the debate a piece of evidence appears to favor. The name Bart should be treated with the same caution. The supplied material claims that the name appeared in audio before it was publicly connected to the case. If the original audio can be authenticated, the recording date can be established, and the name can be independently confirmed, then the chronology could become an interesting lead. But even then, investigators would need to determine whether the name was actually heard correctly and whether it was available through another source. The supplied material also identifies the person as Bart Edmondson, but reliable current reporting reviewed for this rewrite did not independently establish that specific person as an official participant in the Nolan Wells investigation. For that reason, the name should remain attributed to the claim rather than presented as an established case fact. The larger lesson is that an investigation can contain genuine inconsistencies without every inconsistency pointing to the same explanation. One problem might result from poor documentation. Another might result from a witness misunderstanding a detail. Another might be a genuine contradiction that investigators need to resolve. Treating every discrepancy as part of one theory can actually make the investigation less accurate because it prevents individual questions from being tested on their own merits. That brings the focus back to the central question in this part of the story: what can actually be established? Point 10 is useful only if it is connected to evidence that can be checked. The fact that a claim sounds plausible does not make it established. The fact that a detail is unusual does not automatically make it suspicious. And the fact that several people online reached the same conclusion does not turn that conclusion into an official finding. What matters is whether the underlying source can be verified, whether the timeline holds up, and whether independent evidence supports the same interpretation. That standard should remain consistent no matter which side of the debate a piece of evidence appears to favor. The independent autopsy should not be confused with a final determination of what happened to Nolan. The preliminary findings released on July 22 were described as undetermined pending investigation. Dr. Mitchell encountered limitations that affected what he could determine. Reports also noted that the examination could not resolve every question about possible mechanisms of death. That is why the wording matters. Undetermined does not mean that a crime was established, but it also does not mean that every possible explanation was ruled out. It means the available information did not permit a definitive conclusion at that stage. Public reporting at the time also indicated that the official state autopsy and toxicology results had not yet been publicly released, so those records should not be described as if their contents are already known. This is also why the public should pay attention to how claims are phrased. Could be means something different from was. Reportedly means something different from confirmed. Undetermined means something different from ruled out. No initial indication means something different from proved impossible. These distinctions are small in wording but large in meaning. In a developing case, careful language helps viewers understand the evidence without accidentally turning an allegation into an established fact. That brings the focus back to the central question in this part of the story: what can actually be established? Point 11 is useful only if it is connected to evidence that can be checked. The fact that a claim sounds plausible does not make it established. The fact that a detail is unusual does not automatically make it suspicious. And the fact that several people online reached the same conclusion does not turn that conclusion into an official finding. What matters is whether the underlying source can be verified, whether the timeline holds up, and whether independent evidence supports the same interpretation. That standard should remain consistent no matter which side of the debate a piece of evidence appears to favor. What actually matters moving forward is the primary evidence. That means original medical reports, authenticated digital records, GPS information, original photographs and recordings, properly documented witness statements, and official records that can be compared against one another. The alleged social media post should be preserved if it exists. The boat references should be reconciled. The photograph should be technically examined if there is a legitimate authenticity concern. The phone should be forensically examined through proper procedures. And any accusation of a cover-up should be tested against evidence of intent rather than relationships alone. This approach may sound slower than a dramatic theory, but it is much more likely to produce an answer that can withstand scrutiny.